What's unfolding feels less like a sports drama and more like a real life legal showdown, with the lead character being a living, breathing person and the consequences playing out on a national scale. What the WNBA appears not to fully understand is that legal precedent holds immense weight. If Caitlin Clark's situation ever transforms into a formal case, it wouldn't just set a benchmark for women's basketball, or even sports in general. It could redefine workplace protections in elite, high-pressure environments across industries. That's why this moment carries so much weight. It's not just a controversy rooted in bad officiating or bruised egos. It's potentially the makings of a historic civil rights case wearing a basketball jersey. If mishandled, the consequences won't stop at poor viewership or slumping merch sales. The league could lose legal shields, public credibility, and crucial financial backing. And the bitter twist? A league founded on principles like empowerment, inclusion, and equality now finds itself accused of betraying those ideals directly, harming the one player who's doing more than anyone to keep it relevant. Clark is far from an ordinary rookie. She might very well become the most pivotal figure in the legal history of women's professional sports. If she ever chooses to respond, not through a buzzer beater but through legal channels, the impact could ripple well beyond the WNBA then. There's the Olympic exclusion, a decision that left the league's most celebrated figure off the Team USA roster. When you add that to public dismissals like team owner Sheila Johnson suggesting Clark didn't deserve Athlete of the Year, a troubling pattern starts to emerge. A pattern of minimization, of sidelining, of strategic omission. Any civil rights litigator would be taking notes and seeing opportunity. And now, the spotlight is growing hotter. Washington has taken notice. Senator Jim Banks has already sent a formal inquiry to WNBA Commissioner Kathy Engelbert, demanding answers. Congress is circling. If they follow through on hearings, as the Wall Street Journal strongly suggests they should, then the league's top brass, including Engelbert and possibly NBA Commissioner Adam Silver, could find themselves sworn in and facing tough questions. And all of it would unfold live before the American public. The U.S. Department of Labor has jurisdiction over workplace safety. If they step in, this wouldn't just be a matter of compliance violations. It could trigger legal proceedings. Even more serious, the Department of Justice's Civil Rights Division. If they begin an inquiry, it won't stop at surface-level issues. Their investigations are exhaustive. Every piece of correspondence, every meeting recap, every testimony from officials, staff, and whistleblowers would be up for scrutiny. If that happens, the WNBA wouldn't just be in trouble, they could be in existential crisis. And then there's the looming threat of antitrust scrutiny. Sports leagues in the U.S. benefit from unique legal exceptions that allow them to operate more like monopolies than traditional businesses. But if lawmakers decide to revisit or revoke those protections, the WNBA could be forced to compete under normal market conditions, stripped of their advantages, facing stricter oversight, and subject to far more legal accountability. That's the kind of nightmare scenario that rattles league commissioners behind closed doors, even to a casual observer. The pattern is visible. Clark's absence from the court has coincided with a notable drop in physical play during fever games. The shift in how games are officiated with her on the bench versus on the court is glaring. It's the kind of comparative evidence lawyers dream of. Real-time, easy to document, impossible to ignore. Still, not a single suspension has been issued for the flagrant fouls she's taken, not one. That's not oversight. That's selective punishment. That's discrimination by omission. When similar actions result in different consequences depending on who the target is, that's the textbook definition of unequal treatment. The hit by Marina Mabrey wasn't basketball, it was a blindside blow, more reminiscent of a tackle than a play. The fact that it was shrugged off as routine is alarming. If that had happened to any other player, would it have been taken more seriously? Or was it minimized because it happened to her? And don't forget DJ Carrington's dangerous move last season, another near miss with potentially devastating outcomes. These aren't just hard-fought games, they're warning signs. At this point, Clark is one unsanctioned foul away from a career-altering injury. That's not hyperbole. That's a reality grounded in game footage, medical risk, and mounting data. What makes all of this so unsettling is the source. This isn't coming from tabloid headlines or fan-driven outrage. It's coming from the Wall Street Journal, a publication that operates in the realm of finance, law, and policy. When a journal built on economic reporting and corporate accountability starts connecting dots between a basketball league and civil rights violations, the alarm bells should be deafening. Clark isn't just increasing ratings, she's cultivating a loyal consumer base. Engagement stats show fans aren't just tuning in, they're committing, downloading apps, interacting on social platforms, spending money. And if the league doesn't recognize that audience loyalty, or worse, takes it for granted, then every financial hit that follows is well earned. Because everyone's paying attention now. Sponsors, fans, elected officials. If this snowballs into a full-blown federal investigation, there may be no salvaging what's left. At that point, it won't be about basketball, it'll be about rights, responsibility, and whether an institution built on progress has become a symbol of everything it once opposed. The rookie phenom narrative has transformed into something much bigger. The Wall Street Journal didn't just report on a controversy, they tugged at the thread that could unravel an entire league. And the next chapter of this story may not be written in a game recap, it may be typed into a federal court filing. Workplace culture patterns aren't just measured in physical safety or financial fairness. They're equally defined by emotional and psychological well-being. When that lens is applied to Caitlin Clark's current reality, it's obvious that this isn't simply a difficult rookie season. She's not just playing basketball, she's navigating a hostile environment. And the officials, the ones meant to uphold fairness, have effectively gone silent. But the Wall Street Journal didn't stop at the Harris v. Forklift Systems precedent. It went deeper, citing Texas Department of Community Affairs v. Burdine. 1981. Supreme Court case that changed the game and how disparate treatment under Title VII is evaluated. The principle is simple yet powerful. If an employee shows they're being treated differently than others in comparable roles, the responsibility shifts to the employer to justify that treatment with a valid, lawful explanation. If Clark were to pursue legal action, her legal strategy would be straightforward and backed by data. They would start by presenting the pattern, statistics on flagrant fouls, disparities in whistleblowing, first-hand accounts from players and coaches, and public statements that hint at targeted aggression. Under the Burdine framework, once this foundation is laid, the onus would fall on the WNBA to provide a legitimate, non-discriminatory rationale for why Clark has faced such relentless physicality with little consequence for offenders. That's a legal situation no organization wants to find itself in, especially when discovery enters the equation. Internal emails, chat logs, coaching notes, if any communication exists where someone jokes about letting Clark get knocked around as a rite of passage or implies she needs to be put in her place, that's not just poor taste. Admissible evidence. Discovery is often where discrimination cases are either fortified or destroyed. The Journal knows it. They're not offering vague concerns. They're sketching out a prosecutable framework for a lawsuit in real time. And with every day the league hesitates to act, that framework inches closer to being used. This isn't sensationalism. It's a documented, step-by-step warning written by financial journalists, not sports writers. That alone signals how serious the situation is. When business publications are mapping out Title VII pathways, someone with legal expertise is already connecting the dots behind the scenes. And if they are, the WNBA should be preparing for legal fallout. It's not PR damage control. It's also critical to remember that civil rights law doesn't demand proof of intentional bias. Discrimination often exists in subtle patterns, in habitual inaction, in who gets protected and who gets left vulnerable. If Clark's legal counsel can demonstrate that her treatment tanned the lack of protection impacted her disproportionately because of her identity, whether tied to race, gender, or simply because she's seen as the league's media darling, then that could be enough to trigger legal proceedings. And that's before the issue of retaliation is even raised. Legal teams always ask, how did the organization respond when concerns were raised? Did the league investigate? address the issue, or did they look away and allow it to fester? In court, ignoring a problem, especially after it's been made public, can be more damning than the original misconduct, because inaction after awareness implies tolerance. This situation wouldn't be so volatile if Clark weren't who she is. But she's not just another athlete. She's the centerpiece of the WNBA's rise into the cultural mainstream. Sells out arenas. She boosts television numbers. She generates merchandise revenue. She's the marketing engine the league has long needed. So when someone like her raises red flags and others echo them, and legal precedent supports them, the league's failure to act becomes not only irresponsible, it becomes indefensible. The Wall Street Journal also drew attention to potential enforcement scenarios similar to Title IX, hinting at the kind of federal oversight that reshaped collegiate sports. When the Department of Education cracked down on schools over gender-based inequities, the fallout was sweeping. Now picture that kind of institutional power being directed at a professional sports league. Imagine the headlines if the Department of Justice launched a civil rights inquiry into the WNBA. Sponsors would disappear. Financial backers would distance themselves. The league could spiral into crisis overnight. What makes all of this even more astonishing is that none of it is secret. The evidence isn't buried in legal files, it's out in the open. The physicality is broadcast live. The Olympic snubs are reported. The numbers have been published. The commentary is on the record. It's like watching a case build itself. In public view, step by step, while those in charge act like nothing's wrong. Independent Rights Watch Group isn't pulling any punches, and the article doesn't either. It calls on Congress to haul WNBA leadership into hearings, demanding accountability for every injury. Every questionable call and every game Caitlin Clark has been forced to miss. What we're seeing isn't just another media frenzy, it's a reckoning. A league that may have crossed a boundary now finds itself facing scrutiny that won't be easy to dodge. Let's look at the figures, because they don't exaggerate. Clark isn't your average rookie. She's the catalyst behind a staggering surge in the WNBA's popularity. Viewership has skyrocketed by 366%. User engagement on digital platforms has jumped 613%. Sales of league merchandise, up 601%. These aren't small gains, these are transformation-level numbers. The kind of growth that rescues entire organizations, renegotiates billion-dollar TV contracts, and births cultural dynasties. Clark is doing for the WNBA what Michael Jordan once did for the NBA, pulling it out of niche territory and into prime time. Relevance. Yet, rather than being protected, celebrated, or even fairly treated, she appears to have become the league's sacrificial lamb. As the article puts it, it's like winning the lottery, only to be penalized for being too successful, rather than shielding their biggest asset. The league has left her exposed to repeated hits, unchecked aggression, and in many cases, silence from officials. This isn't just a matter of perception either. Data backs it up. Clark has been the victim of 17% of all flagrant fouls in the league. That's not just a slight uptick, that's twice the rate of any other player. It's not random, it's a statistical red flag. And for civil rights attorneys, that kind of disparity is invaluable. It's the pattern that builds legal firepower. It's what's known as disparate treatment, being subjected to harsher conditions than peers without lawful justification. In the courtroom, numbers like that can spark massive legal consequences. When a league's most marketable athlete is taking repeated hits, literal and figurative, and the numbers confirm it, stops being an issue of bad officiating. It turns into something much bigger. Negligence, possibly even systemic bias. And the situation is no longer being whispered about. It's being confirmed by players themselves. Sophie Cunningham didn't beat around the bush. She spoke openly, saying that the WNBA's most valuable player isn't being shielded by the officials. That's not speculation. That's a player who's been on the court, seen the contact up close, and publicly labeled it as targeted. What she added made things worse. Cunningham revealed that locker room discussions were happening around welcoming Clark to the league. Meaning from the outset, there was a conscious, coordinated effort to go after her. That's not physical. Play that as retaliation. That's bullying wrapped in sportsmanship, Van Clark herself, who has kept her composure through all of this, couldn't ignore it forever. She admitted that opponents are consistently more physical with her, and that infractions against her often go uncalled when they would be flagged for others. That's the very definition of a double standard. One set of rules for her, another for everyone else. It's a punishment for being elite. The consequences have already been costly. Clark has missed 10 games due to injury, including the All-Star Game marquee event. The impact was immediate. Viewership for that game plummeted by 55%. That's a multi-million-dollar loss. And when you realize that her injuries came from plays that would be considered violent offenses outside a basketball arena, it becomes impossible to write this off as normal wear and tear. Then the conversation turned to race-charged, emotional, and now possibly legally actionable. Aja Wilson suggested that Clark's experience in the league may be shaped by racial dynamics. Under civil rights law, that doesn't need to be proven through direct evidence of intent. It's enough to demonstrate that certain practices or outcomes disproportionately affect someone of a specific race. That alone can trigger federal involvement. The article ties all of this to landmark civil rights cases decisions that have defined workplace protections for decades. One of the central cases it draws from is Harris v. Forklift Systems 1993, Supreme Court ruling that reshaped how we define a hostile work environment. The decision made it clear, economic harm isn't necessary to prove mistreatment. Conduct is frequent or severe enough to create a hostile, intimidating, or abusive environment. That alone is enough to show a violation of Title VII. Now apply that to Clark's situation. Repeated fouls. Physical aggression. Known plans to target her. Public exclusion from Olympic representation. League unwilling to intervene. If the average employee faced even a fraction of that in a regular workplace, HR would treat it as a crisis. In the WNBA, it's being shrugged off or worse, encouraged. That's why Harris matters here. It shows that civil rights law isn't just about racism or sexism in their most obvious forms. It's about hostile conditions, repeated abuse, and systemic indifference.